Hi, welcome back to Battle with Ola. My name is Mojola Olua and I'm super thrilled to be here once again. We are now 12,000 subscribers strong. Thank you, thank you, thank you so much. Thank you to everyone that has subscribed to the channel. Thank you for your likes, your comments, your emails, for sharing the videos, for introducing other people to the channel. Thank you. I thank you for all your comments on other social media. I am really grateful to God and I'm thankful for all of you. Thank you, thank you, thank you so much. Today I want to talk about something that's very important, as I always say, and something that you will find very, very useful. We're going to make it a twin video because if I break it into two, there are two separate topics or concepts in law, but if we break it into two, there may be a slight disconnect. So let's talk about it together in one video. We want to talk about expert evidence, opinion, evidence. Expert evidence, opinion, evidence. Don't forget that this channel is as practical as possible when it comes to Nigerian law. We've talked about hearsay evidence. I think we made the video about 4 years ago. Please go watch it if you haven't seen it. And today we're talking about expert evidence and opinion evidence. In another video, we're going to be talking about character evidence. There are different types of evidence and classifications according to the Nigerian Evidence Act. And I find that this is very important for lawyers, especially in litigation, for laymen, for law students, even for lawyers who are not in litigation. I'll give you an example, as we go. What is opinion evidence? Let's start from that. As the name may imply, opinion evidence refers to evidence that is based on opinion. What you think, what you feel, what you have concluded from a set of facts, what you can infer from what you know of a matter or a situation is your opinion. So, for instance, you would get up in a meeting and say, my own opinion is that, in my opinion, this is what we should do. On social media, you tweet and say, IMO, in my opinion, this is what we should do. Those things are inferences you have drawn from a set of facts, from things that have happened. So opinion is not facts, different from facts. The law is always dealing with facts. So generally in law, in Nigerian law, opinion evidence is inadmissible. That is what you think, what you feel, what you can infer from a set of facts is not admissible. And the court held in AMPP and Usman that opinion evidence is not admissible because only the courts have the exclusive preserve to draw an inference from a set of facts. So opinion is left to the courts. What you should present is the facts, what has happened in a particular matter. That is what you should present. That is what you can present. Then the court will draw an inference. The court will give its own opinion, and that is the judgment of the court. And because the court is trained to do this, and the court is guided by so many rules and regulations, and the court is also clothed with power, with latitude to make this opinion, you would find out that the opinion of the court is usually always, or ideally should be logical, should be perfect, and should serve all parties. It should mete out justice, and it should do what is fair and what is right in each situation. We're going to be looking at the Evidence Act, literally reading and interpreting several portions of the Evidence Act in order to understand opinion evidence and how expert evidence come in. So let's do some reading. I'm reading from sections 67 downwards. So we're going to be pausing and interpreting as the case may be until we arrive at the end of the sections that talk about opinion evidence and expert evidence under the Evidence Act. I know that we've not defined or explained expert evidence, but you're going to see it in a short while. Section 67 of the Nigerian Evidence Act 2011. The opinion of any person as to the existence or non-existence of a fact in issue or relevant to the fact in issue is inadmissible, except as provided in section 68 to 76 of this act. Where there's a rule, there are several exceptions, usually in law. So now the rule is in section 67 to say that your opinion does not count before the court. Opinion evidence is not admissible. In fact, I was sitting on a panel recently, just about 3 days ago or 2 days ago, and we had called a witness to a fact-finding panel. We had called a witness to testify or to explain what eyewitness testimony. Basically, you were at the scene of events. some events unfolded. We're trying to get to the root of the matter. Tell us what you saw and what you experienced. Then he said, oh, this person did this, that, this, that, this, that. And then he goes on to say, well, what I can say about this person is that they are traumatized, they were hurt by certain events, that's why they reacted in that way. Then I let him know, are you creating an intent for them? He said, well, it's not really a matter of intent. It's just saying that because, we react to situations differently, so they were probably reacting to this. I said, well, at the end of the day, that is your opinion, which is good, which is fatherly, but this is a fact-finding panel. We deal with facts, not opinion. So the opinion of a witness before us does not count. What we need to extract from you is facts. Now let's look at the exceptions under the rule. 68 now. When the court asks to form an opinion upon a point of foreign law, customary law or custom, or of science or art, or as to identity of handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, customary law, or custom, or science or art, or in questions as to identity of handwriting or finger impressions are admissible. Essentially, the court has created an exception for expert opinion. So the court is saying that if you're an expert in the following fields, your own opinion, that is the conclusion, the inference that you draw from a set of facts, will be admissible before the court because you're an expert in that field. And the court has outlined the fields and will be giving different examples. So expert opinion is an exception to the general rule on opinion evidence, and it is admissible. So that's where expert opinion come in. I hope you're following. Let's look at some of those exceptions in greater detail. Section 68(2) goes further to say that persons so specially skilled as mentioned in subsection 1 of this section are called experts. So who are these experts? They are people who are experts in foreign law, customary law or custom, science or art, handwriting or finger impressions. They are experts. I've witnessed a court proceeding where the court had invited an handwriting expert to look at the handwriting of someone that had executed an agreement to confirm if that is their handwriting when placed beside other documents purported to have been made or executed by them. So that kind of person, that is their line of trade, that is their profession. They are versed, they are skilled in determining the handwriting of persons, connecting the writings to the hand that wrote it. So that person is an expert. Customary law too. People can become, especially when we go down in the act, you will see that, for instance, traditional rulers, generally we call them the custodian of culture and tradition. So if we have a baale or a king in a society now, it can be called upon as an expert on the customs and traditions of that locality. And for that purpose, he would be or she would be an expert, properly so called. 69, I'll just run through everything now. Where there is a question as to foreign law, the opinion of experts who in their profession are acquainted with such law are admissible evidence of it, though such experts may produce to the court books which they declare to be works of authority upon the foreign law in question, which books the court, having received all necessary explanation from the expert, may construe for itself. For instance, Professor Itse Sagi, is a constitutional law expert in Nigeria, is known for that area of law. It can be called upon in court and his opinion given on a certain aspect of constitutional law, maybe an interpretation of an aspect of the constitution. It can be called upon, and in that regard, he will be an expert and his opinion will be admissible. His opinion, not even facts, his opinion, because he's an expert. For instance, Professor Damilola Olawi, SAN, is an expert in environmental and energy law. International expert, widely known. If he were to be called upon to give his opinion on any area of environmental and energy law in court, that opinion will be admissible as an exception to the general rule on the non-admissibility of opinion evidence. In deciding, that's section 70 now, in deciding questions of customary law and custom, the opinions of traditional rulers, chiefs, or other persons having special knowledge of the customary law and custom, and any book or manuscript recognized as legal authority by people indigenous to the locality in which such law or customs apply, such law or custom applies, are admissible. I've explained that. Facts not otherwise relevant are relevant if they support or are inconsistent with the opinion of experts when such opinions are admissible. Now let's look briefly at opinion of non-experts. Now, how do people become experts? They become experts by training and by experience. By training and by experience. For instance, in rape cases, when I was a prosecutor, we would normally request, the doctor that attended to the lady, that tested, that examined the nominal complainant, and wrote a report to come to court to testify when we are gone to trial. He has to testify about what he tested, what he examined, what he found out, because he's an expert in that field. And he can draw inferences from what he discovered, what he looked at, what he saw, questions he asked, and the answers that were provided. He can draw an inference that will be admissible because by profession, he is an expert. So expertise comes from not only education now, but from training and experience. So someone might not even have gone to school. For instance, in the case of chiefs, who are custodians of customs and traditions in a locality, they may not have gone to school, but by experience, by length of time, progression of time, they are the ones that have become the custodian. They've seen it play out. They've seen it evolve. It was handed to them and they have preserved it and practiced it over a period of time. As such, they can be regarded as experts. Non-experts, 72. When the court asked to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is admissible. What examples can you think of? A secretary, for instance. A secretary, has worked with his or her boss for probably a long time. Some secretaries work with bosses for as much as 30 years, 20 years, even 10 years. They can be called, they are non-experts in handwriting, but because they've become accustomed by virtue of their work to the handwriting of the person in question, they can be called upon and the evidence will be admissible. 72.2. A person is said to be acquainted with the handwriting of another person when he has seen that person write, or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business, documents purporting to be written by that person have been habitually submitted to him. If, for instance, I'm working with a principal, maybe I've worked with him for like 7 years, and my handwriting is in question, it can't be called upon because I would normally or regularly draft documents and submit to him for vetting, for final approval, for additions and subtractions and whatnot. So it can be, he's a non-expert, but his opinion on my handwriting will be admissible because he is accustomed to my writing because we work together. 73.1. When the court has to form an opinion to the existence of any general custom or right, the opinions as to the existence of such custom or right of persons who would be likely to know of its existence, if it existed, are admissible. I'll give an instance. Say maybe we're trying to establish if a marriage practice is actually valid, is actually the practice of a group of people. An old man in the community can serve that purpose. He's not the chief, he may not be the Bale, but he's an old person. Probably has been living in the community for 60 years. Was there, when probably the people whose marriage is in question were born. That kind of opinion can be admissible if it can be shown that if we're looking to establish the veracity or the validity of this custom or tradition, these are the people that should know it. So that kind of person, the opinion will be admissible. 73.2, the expression general custom or rights includes customs or rights common to any considerable class of persons. 74. When the court has to form an opinion as to the usage and tenets of any body of men or family, the constitution and governments of any religious or charitable foundation, or the meaning of words or terms used in particular districts or by particular classes of people, the opinions of persons having special means of knowledge on the matters specified in this section are admissible. If, for instance, you wanted to know something or establish the veracity of something about probably the Roman Catholic Church, for instance, the Pope would be, his evidence would be admissible, the Pope, because by virtue of his position, he should know, he should be able to confirm this is our practice, this is what we do, this is our custom, this is our way. He should be able to establish that, and different other instances that have been given. 75. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject, is admissible, provided that such opinion shall not be sufficient to prove a marriage in proceeding for a divorce or in a petition for damages against an adulterer or in a prosecution for bigamy. On the existence of a relationship, for instance, a father should know if his daughter is in a relationship with someone or not. Possibly they've even done the traditional marriage, and they've met, families have met, so members of the family who were there when they met, by virtue of their involvement, they should know, and so their opinion may be admissible in court as proof of the existence of such kind of relationship. But of course, this section is qualified to say that such opinion is not going to prove marriage in a divorce proceeding. It's not going to prove adultery, and cannot be used to prove bigamy. So these are the various delineations of opinion evidence under the Evidence Acts. I hope you understand. We have talked about 3 different things today. We've talked about opinion evidence being inadmissible generally, and then we've talked about the exceptions, which is expert opinion, and in some instances non-expert opinion. That's all I have for you in this video. I will see you in my very next video. Don't forget to subscribe. Toodles!